Okay, this is a reviewer for evidence covering object evidence. So the nature of object evidence is under Section 1 of Rule 130. So it's evidence that is addressed to the senses of the court. Okay? Simple, easy, let's go. Now, a person's appearance, where relevant, can be admissible as object evidence. So, the same being addressed to the senses of the court. Ocular inspection of the body of the accused is also permissible, and the right against self-incrimination cannot be invoked against object evidence. So, object evidence has to be 1, relevant to the issue, and 2, it's appreciated by the senses of the court. Is this an inaccurate definition? Sort of, because of the 3 kinds of evidence, you have just 3, but testimonial evidence also appeals to the senses because you have to physically hear it, and also you're observing the demeanor of the witness. In the definition given by Wigmore, this is a bit more accurate, where object evidence conveys a first-hand impression. So testimonial evidence gives a second-hand impression because it's a recollection of what was previously perceived and is now being, that perception is being communicated and appreciated by the court through their senses now. So object evidence conveying a first-hand impression is a bit more accurate than object evidence is that evidence which is relevant to the issue and appreciated by the senses of the court. Can object evidence be presented outside of a courtroom? Yes. In the inspection or the view outside of the courtroom of any scene or object relevant to the issue should be made in the presence of the parties, or at least with previous notice to the parties, so that they may show the object to be viewed. Such inspection or view is a part of the trial inasmuch as evidence is thereby being received and is expressly authorized by law. So, object evidence is also called real evidence, but object evidence can actually be both it could be real or demonstrative. So real refers to the object itself. So in a crime where someone was shot with a gun, it's going to be the gun, or if it's like a buy bust, it's the drugs, right? Demonstrative evidence, on the other hand, is a depiction or demonstration of an action or object. So the photo of a gun. But remember, the photos with the revised rules can also be documentary, right? So a photo of a gun could be either documentary evidence if it's offered to prove the truth of the depiction therein, or it could be object demonstrative evidence if it's there to prove the existence of the the existence of the photo itself, or the existence of the gun itself. Yeah. Object if it's regarding the existence of the thing itself. So, the requisites for the admissibility of object evidence are: first, it has to be relevant; second, it has to be authenticated by a competent witness; and third, it has to be formally offered. The object needs to be formally offered. So, relevancy, authentication, and formal offering of the object evidence. The general rule is that when an object is relevant to a fact and issue, it may be exhibited to, examined, or viewed by the court. However, the court could refuse the exhibition of the object evidence and instead rely on testimonial evidence alone if the exhibition is contrary to public policy, morals, or decency. So, you want to prove that you don't have to show the body of the dead person, basically. The court can say, we can go on other forms of evidence. We don't need to see that. It's gross. Or if it would result in delays, inconvenience, or unnecessary expenses out of proportion to the evidentiary value of the object. You don't need to present every single object that was involved in it. What if it involved like a 50-foot statue? If the evidence could also be confusing or misleading if presented into court, then the court can refuse the exhibition of the object evidence. Or if testimonial or documentary evidence was already presented clearly portrays the object in question, so that the actual viewing of the object is unnecessary. So, object evidence has to be competent and it has to be authenticated. So, and it also has to be relevant. Otherwise, you're just showing them like trinkets and they have nothing to do with the issue at hand. So, the evidence or the object evidence is authenticated because you need to show that the object being presented is the very thing that is either the subject of the suit or the one involved to prove an issue in the case. The authentication is to be made by a competent witness, and this witness has to have the capacity to identify the object as a thing involved in the litigation. The authenticating witness here, can testify only to facts that are within their own personal knowledge, that is, which are derived from their own perception. So this doesn't mean that if you're presenting, say, a photograph, or if you're presenting, say, a photograph, that doesn't mean that the photographer is the one who has to authenticate it, right? It can be someone else. It just has to be someone who has personal knowledge, which is derived from their perception of the object. So the requisites for the admissibility of, like, say, a tape recording or CCTV. So if there is a CCTV custodian who is authenticating footage which shows A attacking B, okay? This authenticates as to the first witness for the party, but did not, the CCTV custodian authenticates as the first witness for the party, but did not actually witness the events. They're just the custodian of the CCTV. After authenticating the video, can the video then be admitted as evidence of the fact of the fight? So at this point, the CCTV footage has been authenticated as the first witness for the party presenting that footage, but they did not witness the event. At that point, the authenticated video is documentary. It's documentary evidence, so it can be admitted as evidence of the fact of the fight, as evidence of the truth of what is being depicted within the video itself. After authenticating, can the video already be offered in evidence? Remember, multiple admissibility. So while it is documentary evidence, it still can't be offered into evidence as documentary evidence, but it can be offered into evidence as real or object evidence. So you do the offering of the CCTV by stating the purpose. So the exception here would, so if it was documentary and you wanted to do the formal offering of the video as documentary evidence, the custodian authenticated the CCTV footage, but they didn't witness the events. So to offer it as documentary evidence, someone with personal knowledge of the events of the fight needs to testify first regarding the fight, and then you can offer the video as documentary evidence. But as it stands, it can be offered as real evidence. So except here, if the video was offered to show the content, basically, if the video was offered to show the contents, it's documentary, and at this point it was authenticated, but it still can't be offered as documentary evidence because the CCTV custodian had no personal knowledge of the events of the fight. However, the video can be offered to prove that the video exists, and the authentication by the CCTV custodian is sufficient, so it can be offered as real or object evidence. Next, what if there's a witness who testifies, and then you show that witness the video authenticated by the CCTV custodian, and then you ask the witness questions regarding the video, like, who did this at timestamp blank, or what happened at timestamp blank, okay? Then you can present the video, offer the video as documentary evidence in the case. So that's how it can get a bit confusing between object evidence and documentary evidence. Real is the object itself, so the gun or the drugs, and demonstrative object evidence is a depiction or demonstration of any action or object. So actually here, the CCTV photo would be object demonstrative evidence. Okay, if the video was being presented to the witness, when the video is being presented to the witness, it can be object evidence if the purpose is not to prove the contents, because otherwise it would be documentary, but instead to prove the incident because you have testimony already. It's demonstrative because it depicts the same matter already admitted. Again, the video, when being presented to the witness, is object evidence because it's offered not to prove the contents, but to prove the incident because you already have a testimony from another witness who saw the video. Who saw the event. It's demonstrative because it depicts the same matter already admitted by that other witness who saw the event. So here, is the video an object of the case? Going back to the whole body of the crime thing. If it's a civil or criminal case, likely no. It's not an object of the case because it's not part of the body. Just go back to that discussion. The real object would be, say, the object that was involved in the fight. Was their gun? Was their drugs? That is an object of the case, but just remember the confusing corpus delicti discussion. And on its own, the video cannot stand and needs testimony, which is admitted as soon as it's said, provided there is no objection. So say if the crime is someone was shot by a gun. The gun is the object of the crime, and that is real object evidence. But there's also CCTV of the crime. While this can be real evidence to prove the existence of the footage, the CCTV is not an object of the crime. So the pistol is both the object of the crime and it can be real object evidence. But the CCTV is not an object of the crime, but it can be real object evidence to prove the actual existence of the CCTV. It could be documentary if it's offered to prove the truth of the contents therein, and it could be demonstrative object evidence if it is used to aid the presentation of a fact which is already admitted. So just remember, when you got your CCTV, if it's offered to prove the fact already admitted because you had another witness who had personal knowledge of what happened, like the actual events, the demonstrative object evidence, the video, can be given to aid the presentation of the fact already admitted. So they're testifying, you say like, okay, what happened at this time stamp? What happened at this time stamp? Can you confirm what you're seeing in the video, right? That's demonstrative. Next, it can be real if you want to prove the fact that the CCTV itself already exists. Like, there is CCTV of this event, and for that, you'd have the CCTV custodian. And then also you would follow, like, the chain of command similar to, like, a dangerous drugs case to show how it got to court, but just for the purpose of this, yeah. So then you can prove the actual existence of the CCTV, and if you offer the CCTV video as, in order to prove the truth of the contents of the video, then it's documentary evidence. Okay. There you go. Now, what about photos? Photos can be real or demonstrative, again, right? So, if it's another case of murder, because we always go to murder because it's so easy to conceptualize. So if it's a case of murder, it could be real evidence, obviously the weapon or something, but say photos of the victim could be real evidence to prove the actual existence of the victim. So this usually would happen if there's like a John Doe, because otherwise you wouldn't present a photo, you'd present the death certificate. And usually there's a medical legal anyway, so you also again wouldn't present the photos to prove the injuries because that's just gross. So to prove the existence of the dead body, there are other things that you could do besides presenting photos. But if it's a John Doe, there's no death certificate. And if the medical legal was contested by an expert, then you can present the photos of the injuries to prove the existence of the dead body and the existence of the injuries. It would be demonstrative again to aid in the presentation of a fact already admitted. So why do you... okay. In this one also we're doing character evidence and just why do we offer evidence? And then, yeah. Okay, so why do you offer evidence? So it can be considered by the court, not offered, and then the court cannot consider it. So a faithful reproduction of the original is as good as the original because it is compared at pretrial marking. What if you had given Exhibition A in pretrial, but the lawyer forgot to formally offer it? In general, then, so you gave an exhibition in pretrial, but then the lawyer forgot to formally offer it. So it's marked, but it was not offered. In general, the court cannot take notice unless 3 exceptions. So 3 exceptional cases where the court can still consider an exhibit that was given in pretrial, but the lawyer forgot to formally offer it. And this is 1, it's identified by testimony. 2, it's attached to the records. And 3, it's an original or a faithful reproduction of the original. So 1, identified by testimony, attached to the records, original or FRO. Identified by testimony, attached to records, original or FRO. And that's the exceptional cases where an exhibit given in pretrial but the lawyer forgot to formally offer it, can still be taken notice of, because the general rule is that failure to formally offer, the court cannot take notice anymore. But what if it wasn't submitted at all and then it wasn't formally offered? Then it cannot be considered because it was not part of the record at all. It essentially doesn't exist in the world of the proceeding. Character evidence, as a general rule, again, it's not admissible. Why is it generally not admissible? This is Rule 130, Section 54. So character evidence is generally inadmissible because it fails the test of relevancy. So it's irrelevant and it's about collateral matters. So, say, for example, take the phrase, religious people can still commit crimes. So, to present evidence that the character of the person, of the accused, is that, oh, they're very pious, it's irrelevant because religious people can still commit crimes. It's about a collateral matter, and it's not about anything materially an issue. The exception, however, to whether character evidence could be introduced would depend if it was criminal or civil. So, if it was a okay, so first, to distinguish character evidence from reputation, okay? Character evidence is what a man is, whereas a reputation is what he is supposed to be or perceived by other people to be. Character depends on attributes that are actually possessed, whereas reputation are attributes which others believe one to possess. Anyway, so the general rule is that character evidence or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. So, general rule, not admissible, Section 54, Rule 130. The exceptions here would be criminal. It would depend on if it's a criminal case, if it's a civil case, and then there are certain exceptions that apply to both civil and criminal cases. So, going first to the exceptions that apply to both civil and criminal cases. First, the evidence of good character of a witness is not admissible until such character has been impeached. And second, the character or trait of character is an essential element of a charge, claim, or defense. So, in civil and criminal cases, generally, evidence regarding the good character of a witness is not admissible until that character has been impeached by the other party. So, in all cases where the evidence of character or a trait of character is admissible, the proof may be made by testimony as to reputation or testimony in the form of an opinion. And then, upon cross-examination, inquiry is allowable into relevant specific instances of conduct, and in cases where the character or trait of a character is an essential element of a charge, claim, or defense, proof may also be made of specific instances of that person's conduct. So that's where it's the same for criminal and civil cases. So for civil cases, moral character is admissible only when it's pertinent to the issue of the character involved in the case. So generally in civil cases, introducing moral evidence or evidence regarding the moral character of someone, it's only when it's pertinent to the issue of, when the character is pertinent to the issue involved in the case. It's more complicated for criminal cases. So there are rules for the accused, the prosecution, and the offended party. So the accused can prove their good moral character. They may prove their good moral character if it's pertinent to the moral trait in the offense charged. So if there's a moral trait to the offense that is charged against the accused, then the accused can introduce evidence to prove their good moral character. The prosecution, on the other hand, while the accused is basically allowed to defend their good moral character, so if there's a moral aspect to the crime charged against them, the prosecution cannot attack the moral character of the accused. So they can't just prove that, no, he's a bad person, unless it's on rebuttal. So, this sort of asks the question, so you can't prove the bad moral character of the accused except in rebuttal. Does that mean in direct you can prove their good character? You don't need to answer that, because why in the world would you as the prosecution introduce that? So anyway, the fact that you can't prove since the prosecution cannot prove the bad moral character of the accused except in rebuttal, it necessarily means that the accused should have first introduced evidence as to their good moral character and made it pertinent to the moral trait of the offense charged. Next, the offended party or the private complainant. So it could be proved, the character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the offense charged. So regarding the moral character of the offended party, it can be established, it may be proved if it tends to establish the probability of the charge, right? But again, the accused can prove good moral character if it's pertinent. And then if they do that, the prosecution can prove bad moral character on rebuttal. So the purpose of presenting evidence as to the good moral character of the accused is to prove that they probably didn't do the act as charged, if especially the act as charged has a pertinent moral trait involved in it. So there. Bad character of the accused, again, can only be done by the prosecution in rebuttal. So unless and until the accused gives evidence of their good moral character, the prosecution cannot introduce any evidence of their bad moral character. However, the character evidence that could be introduced has to be limited to the traits and characteristics that are involved in the type of offense charged. So if you're charged with a rape, you can only talk about your character of chastity. You can't talk about your scholastic achievements, you know? The character evidence, again, has to be limited to the traits and characteristics involved in the type of offense charged. If it's a charge of rape, you talk about the character of chastity. If it's a charge of embezzlement, you talk about the character of honesty. If it's a charge of assault, you talk about the character of peacefulness or propensity for violence. So while the offended party, it can be proved, their character can be proved if it would tend to establish to any reasonable degree the probability of or improbability of the offenses charged. So this is the character of the private complainant. The bad character of the victim is not admissible in murder cases and in rape cases. So in a murder case, if the crime was committed through treachery and evident premeditation, then bad character of the victim is inadmissible because it doesn't matter. And rape cases, if it was done through violence or intimidation. There's also the rape shield rule, where evidence of a complainant's past sexual conduct, any opinion thereof, or of the reputation of the complainant's past sexual conduct is not to be admitted or shall not be admitted unless and only to the extent that the court finds that such evidence is material and relevant to the case. There's also the sexual abuse shield rule. So the following evidence is not admissible in any criminal proceeding involving alleged child sexual abuse. And what's not admissible is evidence to prove that the alleged victim engaged in other sexual behavior and evidence offered to prove the sexual predisposition of the alleged victim. So that's it for, yeah. What was this? Object evidence and character evidence. Okay. We're not going to cover DNA testing in finals, so I guess that's all right. Just to go back to object evidence, the categories of object evidence could be the actual physical thing, so the real object evidence, or a topic evidence, so it has a direct relation. It's the real one, and then there is demonstrative evidence, which is depicting, or to draw an inference in aid of comprehending the verbal testimony of a witness. Okay. Yeah, I think that's good.